in the presentation. At the end of these proceedings, you'll come out with a judgment. In this judgment, I am looking to see some things in this judgment, and these are the things that I'm looking to see. Your findings, your holdings, which will determine the direction this country takes. The first thing I'm looking for is an affirmation that the Steering Committee on the Implementation of the Building Bridges to a United Kenya Task Force report was an unconstitutional and unlawful entity on account of having a constitutional change mandate that is reserved only to Parliament among publicly funded bodies pursuant to Article 94, Clause 3 and Article 256 of the Constitution, and I can even add Article 2, Clause 2 that Dr. Bosso has just mentioned over here. And also, that steering committee was established in contravention of the mandatory provisions of Article 132, Clause 4A of the Constitution that requires the prior recommendation of the Public Service Commission before you establish such a body and appoint people to such a body. On these two grounds alone, everything that came out of the steering committee is unconstitutional, null, void, invalid.
Sorry, you said 132A?
132, Clause 4A.
Okay.
That requires the President to obtain the recommendation of the Public Service Commission before he can establish a public body and appoint people to it. He did not do that. That was unconstitutional. And therefore, everything pursuant to Article 2, Clause 4 that he did is null, void, invalid. Everything the BBI Steering Committee did is null, void, and invalid. The report they produced, including Annex B, which included the Constitution of Kenya Amendment Bill 2020, is null and void, and that is almost word for word the very same bill that was presented for 1 million or 4 million signatures. The version that was printed by the government printer, dated 25th of November, is just a slightly edited version of the one that was contained in the report released by the BBI Steering Committee in October 2020 with the date of 30th June 2020. And you cannot tell me Dennis Waweru and Junet Mohammed authored the BBI bill when we can read what the steering committee in its report to the President gave, and you compare the two versions, the 30th June version and the 25th of November version, and almost word for word. If you are academicians over here, like Professor Gideon Muigai, try and do that when preparing your doctoral thesis. You'll be shot down for plagiarism. If anything, it was a criminal offense, that's exactly what would happen. So what we're having, what we're being told, is that some plagiarists in the name of Dennis Waweru and Junet Mohammed are the ones who are the authors of this bill. No deal. This thing was produced by the BBI Steering Committee because the President used an unconstitutional method to set it up. The whole process was unconstitutional from its establishment, and everything that came out of that entire process is null, void, and invalid. There's another reason that we also need to address based on the submissions by the appellants. They have tried to urge this court, don't look at issues prior to the collection of the 1 million signatures. Don't look at the establishment of the BBI Steering Committee in 3rd of January 2020, where the entire process starts with the unconstitutional purpose of that committee. Start looking at it from when Junet and Waweru came with the 1 million signatures to IEBC. I know that is wrong. I think it's been covered here by severally. We're dealing with a process, not an event. Nevertheless, I can oblige them by looking at Article 251, Clauses 1, 2, 3, and 4, 1, 2, 3, and 10, which talks about an issue that has come here a few times. Are we dealing with a single amendment, or are we dealing with multiple amendments? I know even Dr. Bosso has tried to weigh in a little bit on that. To me, it's very clear. It talks about amendment in the singular, not in the plural. And yesterday's presentation by Counsel Esther Angawa showed the consistency between Article 257 and the referendum provisions in the Elections Act. where there's provision for singular or multiple amendments, etc. There are two distinct issues, but the trump card comes from Article 256. I think that one, is one worth referring to, because it's going to clarify a lot of issues that we've been dealing with over here. Article 256, Clause 1 reads, a bill to amend this constitution may be introduced in either House of Parliament, then B, may not address any other matter. That is singular. Or they want to deal with amendments or whatever, and it's not being a different article, that's neither here nor there. These are different phraseologies driving home the same point. It cannot deal with any other matter. It's dealing with a single matter. And if anybody thought the Constitution was confused about singular or multiple amendments, continue the phrase, apart from consequential amendments, plural, to legislation. The only thing that can be appended to a singular amendment in a constitutional amendment bill is putting in subsidiary laws in the form of legislation that speak to the same issue, but not multiple issue amendments. And on that basis, this Constitution of Kenya Amendment Bill 2020 is dead on arrival. It has over 73 amendments proposals. The moment it came to IEBC, if IEBC was using this yardstick, Chapter 16, for verification purposes, it would have told Junet and Dennis, you've given us a bill that has 74 amendments, we can only deal with the bill with one amendment. If you want to bring 74 different amendments, go and get 74 lots of 1 million signatures out there in the country. Come here with over 74 million signatures. None of them did that. That is what we have here. I know we've spoken about both sides talking about the onerous nature of amending this constitution, but that is it. If you want to amend it, not replace it, amend it, one issue at a time, one matter at a time. Anything outside that matter is not to be considered. So therefore, the BBI bill is dead on arrival. In fact, we're wasting a lot of time here dealing with something that is a fake document. It's a legal phantom, a constitutional charade. And that is what the real two principles, Appellant Uhuru and Appellant Raila, have foisted on this nation, spending huge amounts of public funds, huge amount of national resources in our psyche, but giving us a fake document. It cannot pass a legal muster. Over 1 million people are signing their signatures, their names, to a fake document that has absolutely no value in the law of Kenya. And that is basically what has happened. And that is why some of us who are very unhappy with such fake things happening in this country had to come out from wherever we are. For me, I've come from Rongo. I was very busy doing my quiet issues of farming and maybe a small arbitration here and there. But when you see the country's foundational law being mutilated the way it was being mutilated, people trying to replace and overhaul the Constitution, we have to come out and defend according to Article 3. There's an obligation on each and every single one of us to defend, respect, and uphold this Constitution. And that is exactly what we're doing. And I commend 254 Hope and Dr. Boso for also taking that role, coming in on our own. We're not paid by some whoever. We're just Kenyans who love this country. And we want to defend this country from the sharks who want to mutilate it. And that is why we are here. I'll proceed with my presentation. So therefore, the one thing, it should be very clear, we do not have a popular initiative. Popular initiative is defined in Articles 255, 1 and 2. It is either a draft bill or a general suggestion that is supported by at least 1 million registered voters. What we have here is a bill with multiple amendments, but according to the Chapter 16, that bill should have only one amendment. So it doesn't pass that particular test, so we do not have a popular initiative put before the nation over here. We're wasting time talking about something that doesn't even exist. So it is for this court to strike out this particular issue, and it be a lesson to anybody thinking of bringing an amendment in the future to this Constitution, not to waste anybody's time. It's time for this court to assert its independence and assert its authority, which we the people delegated to you. We're basically asking you to do your job. Now, there were issues, disputes whether it was Junet, Mohammed, and Dennis Oweru who are the real promoters. I will suggest that Junet and Dennis actually fit into the definition of a promoter. Because if you look at, I think, Article 257.4, whoever presents the bill and the signatures to IEBC is termed as a promoter. And therefore, by that definition, Junet and Dennis, since they're the ones who presented the bill, they are promoters. But if you also look at Article 2, Clause 3 of that article, whoever formulates the general suggestion into a draft bill is also a promoter. And the person who formulated, or the people who formulated the draft bill, was this BBI steering committee. And therefore, the Superior Court was not wrong to refer to the BBI steering committee as a promoter of this process. They are defined in the Constitution as a promoter. Dennis and Junet are also defined in the Constitution as a promoter. So we have promoters in plural, which is basically what is provided for in 257. So they are all promoters. And if you go to the organization that appended its signature to the bill on 25th of November 2020, they just said, Building Bridges Initiative, published by the government printer, printed by the government printer Nairobi. They didn't even tell us who's Building Bridges Initiative. We don't know whether it's Junet, we don't know whether it's BBI steering committee, we don't know whether it's appellant Uhuru or appellant Raila, we don't know. It is not defined, but it doesn't really matter. Promoters is plural, and therefore, when you make a finding, since the appellants are trying to bring this issue, we're dealing with a body that died in 30th of June 2020, despite the fact that it was alive, giving letters to the president on 16th of October 2020, being present in person in the ceremonies and everything else. I would suggest that maybe the particular finding and declaration of the court can be altered to something like, a declaration is hereby made that the entire unconstitutional constitutional change process promoted by the steering committee on the implementation of the Building Bridges to a United Kenya Task Force report, by the Building Bridges Initiative, and by the Building Bridges to a United Kenya National Secretariat is unconstitutional, null, and void. In other words, yes, we can change a little bit factual issues to incorporate the additional promoters, but it will not change the effect. The whole bill is still a nullity. It's invalid, and there's effectively no change to the orders of the Superior Court. Now that was the general point which I wanted to deal with, because that is basically why we're here. There's this bill, we're being told, give the people the sovereign authority, let them decide on this thing. But the people cannot decide on a fake document. Let them bring a proper document, and the people can decide on that proper document, but not on fakes. No. I will now turn now to deal with the Kenyatta appeal. They basically came here with a partial appeal, basically attacking my petition in the Superior Court. So therefore, let me turn my attention to addressing the issues that they dealt with, the issues that they raised. The first primary issue that they've raised is that appellant Kenyatta was not served. Amongst my bundle of documents is a supplementary record of appeal dated 8th of June, a very tiny document, which basically is the affidavit of service dated 16th of January 2020, received by the court, date stamped 18th of January 2020, enclosing the email that were used for serving the president and the other parties. It wasn't just him alone. Other parties were also served. The other parties received everything. There was no email bouncing, email returning. The email address doesn't work. And I didn't stop there. In the e-filing judiciary system, there's also a provision when you're lodging documents to request for service by the court. I also requested for that service by the court and paid for it. And after some days, because of the time the petition was filed was 21st of December, before the end of the year, they hadn't effected service, but once they came back in the new year, they effected service, and they recorded it served, including the appellant Kenyatta and other parties who were also served. So there were two forms of service, one by myself by email, one by the court. So when the president's team comes here and says that he was not served and they submit on the law, fine, their submissions on the law are correct.
So just a minute, can you see that, clerk?
It's a very tiny one.
Can you see that? No, you are there.
You are a copy. If you don't, you can have mine for now. It's a very tiny document, very thin, just one.
All right, thank you.
Yes.
Please proceed, but we'll give it back to you.
No problem. So that's basically just to prove all of their case based on non-service is all null and void. But this issue of service now raises an issue, because Appellant Uhuru is known to be one, when he has an opportunity of evading service, he does evade service. There is a case that is cited in my list of authorities, and President Musinga and Justice Gatembo, I know you dealt with it, which was the issue Kenya Human Rights and another versus AG and 6 others, 2019 case, EKLR, which also involved, I don't know, the International Center for Policy and Conflict. The case came from the High Court just before the elections of 2013. And at that time, basically, they were trying to serve parties, including Uhuru and Ruto, and they were having a difficult time until they managed to get a very resourceful process server, who eventually were in a political rally somewhere in Machakos or thereabouts. As they were coming from the podium, before they got into the vehicles, he had a cameraman ready with him, video camera, photographic camera, and they served them. Now, that showed how extremely difficult it was to serve Appellant Uhuru at the time. But they succeeded, and the case went ahead and eventually reached a level at the Court of Appeal. Again, in the media the other day, while the President was touring, he was in the company of one senior counsel, Senator Orengo, and he was saying, watanipata wapi, wanipatie makaratasi zao za kotini, watanipata wapi. Of course, if you go and barricade yourself in State House, an ordinary Kenyan like myself, I cannot penetrate, the security is going to stop me. And this is basically what happened. Again, Senator Orengo was involved in that particular case, whereby he was, I believe, he was representing retired President Mwai Kibaki, and they were suing in a presidential election petition former President Moi. And of course, Kibaki could not serve Moi. Moi was barricaded in State House. And that was, when he came to the court, things didn't work out, and it was dismissed on technicality for failure of service. I know a former president of this court had a very hard time trying to explain how he arrived at that particular decision he made when he was trying to be interviewed for the Supreme Court Chief of Justice. In other words, what I'm saying, we have enough examples of things not having been done right in the past. It is time to do things right. We are coming from the days of darkness. Our senior counsel Hamin told us in the morning, the history of this country is terrible. Maybe some of the young ones don't remember, but we're coming from a terrible history. These are some of the things that are happening in those bad days. Appellant Uhuru is trying to turn us back to those dark days we came from. We chose for ourselves the Constitution 2010. And in the Constitution 2010, when it comes to service, we have Article 87 Clause 3, which deals with service of presidential election petitions and other petitions, which provides for both direct service and indirect service. Indirect can be by adverts in a national newspaper. And that was basically to deal with the mischief of presidents barricading themselves in State House so that you could not serve them. And that is how we, the people of Kenya, decided to deal with that. And bringing in Article 259 on purposive interpretation of this Constitution, when you place an advert in a newspaper, there is no guarantee the person who is being served via the newspaper will actually have read that particular advert. If they don't buy that newspaper, they won't read it. The only thing is that the information is made available to them. They can, if they buy the newspaper, they can read it, somebody might see it and inform them. But the issue in our Constitution is to make available information on a court process available to the person who is a party to court, that they may have the opportunity of answering to that particular scenario. So once you've been informed indirectly, say by a newspaper, even if you don't see the ad, and maybe your cousin somewhere half around the country sees it and calls you, what is happening? I'm seeing your name in the newspaper. Once you have that information, you go to court and deal with the matter. And this is basically what we decided in 2010 to deal with the mischief of parties who were basically playing hardball when it comes to service and then trying to learn the technicality. I wasn't served, rules of natural justice were not followed, I wasn't given a fair hearing, I'm not being treated equally, the court is unfair to me, all sorts of stories. The Superior Court was not unfair to Appellant Kenyatta. The Superior Court had that particular affidavit on file. They knew this person was served twice, one by the court and one by the petitioner. So they were satisfied, we can proceed ahead. Even when they asked the AG, are you here representing Uhuru? And the counsel for the AG would say, no, we are here as AG because we're a party in this particular petition. Even though they went to argue the case, I didn't make any noise because I wanted his voice, whether directly or indirectly, to be heard. I didn't want to shut him out. I know when I had another issue with Appellant Uhuru, petition 360 of 2013, This time he was served via Harambee House, office via Harambee House. Surprise, surprise, when he comes to the court in the High Court, he doesn't send his advocates. The advocates who came were AG Githu Muigai's people. Those are the ones who came to represent him on that particular day. AG was not a party, but they came. All sorts of arguments, such as even Clarence is talking about over here. Oh, the president is sovereign. There's no difference between the president and the presidency. Is one and the same. All sorts of stories. Fortunately, Honorable Justice Lenaola saw through the argument and basically shut them out from that particular. They were not parties to the case. They didn't even have a notice of appointment from anybody. They were not complying with the Article 56 provisions of the Constitution concerning their mandate in the Constitution, and they were kicked out of that particular case. After they were kicked out of that particular case, Appellant Uhuru appointed now Solicitor General Kennedy Ogeto, then in private practice, as his lawyer, and then we proceeded with the matter in that particular fashion. So Appellant Uhuru knows these things. It's not that he doesn't know. He knows these things. It's just that he plays hardball. That is basically what he's doing. So I'm not surprised that he's behaving the same way in this particular matter.
That is which matter? And is it
petition? Now, I just made a reference to it, I think probably in my maybe in my documentation, because no, in the lower court, not in this one, not in my submissions here. But petition 360, Isaac Aluochier versus Uhuru Muigai Kenyatta and William Samoei Ruto, 2014 EKLR.
That is a different matter, not this one.
Not this matter. Okay. I'm giving example. This is,
okay.
We've dealt with one another before.
Right.
In court, we've met in court before. So I'm just telling you, I'm not surprised that he's behaving this way in this matter, because that's his nature. So any issue by the Appellant Uhuru that I abandoned my petition because I didn't serve him, all null and void. He was served. I didn't abandon my petition. I prosecuted to the very end and got the orders against him. Now the issue also arises, was Appellant Uhuru acting in his personal capacity or in his official capacity when he established the BBI steering committee? He said in the Gazette notice that he was acting in his official capacity, signing it as President and Commander-in-Chief of the Kenya Defense Forces. But what he was doing was not part of his mandate as President of Kenya. There is no authority granted by the Constitution for the President to establish an organization or an entity that deals with constitutional change. That is the mandate of Parliament. He was acting beyond his jurisdiction. He did not have jurisdiction, devoid of his jurisdiction. Consequently, he was not performing official presidential functions. He was performing his own private business, the business of trying to change or overhaul the Constitution of Kenya without authority from the Constitution. Therefore, he was not acting in his official capacity. Despite purporting to do so, he was acting in his own personal or private capacity. And that is why I sued him in his private capacity. That's why I sued Uhuru Muigai Kenyatta, not President of the Republic of Kenya. Consequently, because he purported to act as President of the Republic of Kenya, using the authority of the state of office of President of the Republic of Kenya, contravening Article 2.2 that prevents anybody from exercising state authority unless you have authority under the Constitution. He was basically abusing his office. And that abuse of office is a contravention of Chapter 6, Article 73, Clause 1A, Roman 1. And that is why I sought that particular declaration against him. And it is not the first time that these courts have found declarations of contraventions of Chapter 6 against Appellant Uhuru. The very first time it happened was in 2012. Those days used to be chairman of KANU. 4 KANU members got tired of KANU's inactivity. So they took him to court in Mombasa. I believe that is Mombasa Constitutional Petition number 17 of 2010, 2 months after the promulgation of the Constitution. Eventually, a decision came around October 2012, and Uhuru was found to have contravened Chapter 6, specifically Article 77, Clause 2, being an appointed state officer and holding office in a political party. He refused to resign his office in KANU, and he remained the Deputy Prime Minister, Minister for Finance. Those are appointive offices, and therefore he contravened Chapter 6. And there is a Chapter 6 contravention, holding against Uhuru, Appellant Uhuru even today. This issue was even raised to IEBC before the 2013 general election. IEBC just ignored them maybe they fear dealing with Appellant Uhuru or whatever. And so Appellant Uhuru is now president, though if the law had been followed, Uhuru would never have been president, because that finding of Chapter 6, which he never appealed even to date, how many years down the road? 9 years down the road, he's never appealed it. It's a valid Chapter 6 finding against him. So one wonders, why is he making so much noise about a Chapter 6 finding against him, this BBI issue, when there's already an existing Chapter 6 finding against him, in that case from Mombasa, and another Chapter 6 finding against him in my case in 2016, the one that I referred to earlier on. So I'm just wondering why he's making so much noise. Maybe those ones didn't have the high profile. And this one, because BBI, everybody in the country knew something was happening, he decided, no, too many people know about it, I'll come and defend myself. But my point is, whether or not the finding on Chapter 6 in this particular matter is changed or not, there are still 2 existing Chapter 6 findings against him, and despite that, because he has contempt for this Katiba, he's still president, and nobody's doing anything about it. That is the state of Kenya, contempt of the Constitution by Appellant Uhuru. And this is the thing that some of us don't like. And I think something we need to get clear over here. Appellant Uhuru is not the sovereign of this country. We, the people, are the sovereigns of this country. Issues of doctrines are not sovereign immunity. Those sovereign immunity doctrines do not apply to Kenya. If sovereign immunity doctrine applied to Kenya, there'd be no court. Because I, as a sovereign, you can't sue me. And you, as a sovereign, I can't sue you. Nobody could sue anybody else. The dispute resolution business would be dead. Because all of us would have sovereign immunity, because we're the sovereigns of Kenya. So don't tell us Uhuru is a sovereign of this country. No, Appellant Uhuru is not sovereign of this country. He is a subject of us as sovereigns. We're the ones paying his salary. We're the ones appointing him. We're the ones delegating our power to him. He is our employee. Maybe the most senior employee, but still our employee. And when he goes off the rails, we come here to discipline him. Therefore, when you're talking about a declaration against him, that is just to discipline him. It's a slap on the wrist. We haven't yet kicked him out of office, but at least we're disciplining him. There you've gone overboard, our employee. Employee number 1, Appellant Uhuru, you've gone overboard. And that is basically, that's what we're doing over here. So we don't want any nonsense being told he's sovereign, sovereign immunity. Outside Kenya, because of diplomatic conventions, we don't mind, he can ride with sovereign immunity. But here at home, he must know that we are the sovereigns, he is a servant of ours. And he must do what we agreed to do in the Katiba. And that is basically what we're fighting for over here. I now come to these issues of immunity. There's a wonderful case which sets the law in Kenya on presidential immunity. It is most unfortunate that it hasn't been publicized. It's been around for 2 years. Honorable Justice Musinga, you were the president of that Court of Appeal bench. Honorable Justice Gatembo, you were there as another member of that bench. Honorable Lady Justice Agnes Murgol was a 3rd member of that bench. There is no higher court that has looked into this matter of presidential immunity that has come with very clear, precise, well-researched findings and determinations than that particular case of yours. Kenya Human Rights Commission and another versus the AG and 6 others, 2019 EKLR. That establishes the law on presidential immunity in Kenya. It is unfortunate that at the time we're in the High Court, we want that resourceful to have informed the Superior Court of that particular authority. But now we've come here, we've kind of upped our game a bit, and now we're citing that particular authority. That is the law in Kenya. There is nothing like absolute immunity. We had absolute immunity in the retired constitution. You could not institute or maintain a cause of action in a court in Kenya against the president at the time on criminal matters, and when it came to civil matters, provided you wanted some relief, you couldn't institute any court action. We changed that specifically. In Article 43, Clause 4, you can sue the president for criminal misconduct. If he commits a crime, you can sue him, provided the matter has been covered by an international treaty to which Kenya is a signatory. In other words, he does not have absolute criminal immunity. He doesn't. If he commits a crime that falls under the category of Article 43, Clause 4, we can take him to court. Under Article 43, Clause 2, it is very clear. Functional immunity is what he has, in common with other state officers in different functions of public service. That's what he has. If he's performing a function of office, you can't sue him. And I gave the example, which I think is apt, because a lot of noise has been made in Kenya about it, concerning judges. It is his official duty to appoint judges. That's an official function of presidential office. 2 years went by, he refused to appoint them. In such a case, because it was an action or omission on an official function, you could take him nowhere. You couldn't sue him. You can't institute a civil suit against him. Take him nowhere. There, he had immunity. But when he goes beyond his jurisdiction, in setting up BBI steering committee, when he has no power to so set up a committee with a constitutional change function, he's acting beyond the protective cover of functional office. Then it's fair game. That's why I sued him. That's why I'm here. So issues of absolute immunity, that's null and void. This court established the state of law in Kenya on that issue, and I would encourage everybody who wants to enhance their knowledge of that issue to please refer to that court. Very well researched, very well argued judgment, and I commend it to everyone here. Another issue that has come up, we've been told a lot of stories that, oh, we're treating Appellant Uhuru very unfairly, we're infringing upon his political rights under Article 38, his equality rights under Article 27, his freedom of expression rights under Article 23, by trying to place restrictions on him while he's president. He's also a human being. He has human rights just like everybody else has human rights and fundamental freedoms under the Bill of Rights. I raised the issue of Article 24, limitations on those human rights. And of course, the senior counsel on the other side latched on it very quickly. That particular provision says those rights can be limited by national legislation. But I'm not referring to limitations by the national legislation. I'm referring to limitation by the Constitution itself in the form of Chapter 6. You're all state officers. You're not allowed to have a bank account in a foreign country unless you get specific approval from ESCC. That's a limitation on your freedom. Where to possess your property. It's a limitation. It's applicable to all state officers. If you're an appointed state officer, you're not allowed to become an official of a political party. Article 77, Clause 2. That's a limitation on your rights. A limitation on your Article 38 political rights. When you agreed to become a state officer, you knew those were the limitations on your rights that were imposed by working in that particular office. You made a conscious decision, a conscious choice. I agree to limit my rights in these particular areas so that I can serve the people of Kenya in this particular state office. That is exactly what Uhuru did. Appellant Uhuru, when he agreed to serve in presidential office as president, some of his rights that he has, common with everybody else, he agreed to have them limited by the provisions of Chapter 6. And therefore, his people shouldn't come here and tell us, we're infringing on his rights. We're infringing on nobody's rights. It was his own choice, a conscious decision. And he took the oath to uphold, obey, respect, safeguard, protect this Constitution. Yet when it comes down to the reality, he doesn't want to live it. In fact, it's very sad to say this, but our president is not the best example when it comes to constitutional compliance. It's a very sad tale. And it's also very sad that our parliament, which has some authority in disciplining him, actually doesn't bother to discipline him. But that's just the reality of the situation we have over here. And therefore, we are forced, some of us who are private citizens, to come and try and defend the Constitution. Yet we have parliamentarians who are paying hefty salaries every month who are supposed to be doing such a job, but they're not doing that job. That's the sad state of Kenya today. Consequently, Appellant Uhuru has basically contravened Chapter 6, not just Article 73(1)(a). In my submissions, I also show how he has contravened Article 73(2)(b) and also Article 75(1). I know I did seek declarations for those ones in the Superior Court. We just wanted to drive home a message. Just get one simple one to kind of discipline him a bit. Tap on the wrist, a slap on the wrist, just to bring him back to behave properly. We weren't seeking to get him kicked out. If you wanted to get him kicked out, we can go to try and persuade Parliament to impeach him and all that. But we just wanted to drive home the point. Appellant Uhuru, the president of this country, please obey the law. Stop disregarding this category of us, especially when you're the #1 citizen of this country. You took the oath to obey, respect, uphold, and defend this Constitution of Kenya, and you're not doing it. Instead, you're the one now leading the process of amending and tearing apart this category of ours. It is not on. And these are some of the things that annoyed me as a Kenyan. especially in the Jamhuri Day speech last year, when he totally tore the Katiba. And I was wondering, I mean, is it right to use a national day for Jamhuri Day? A whole president tearing apart the Katiba. That is why, a few days later, I filed this particular petition. I was annoyed. He annoyed me. And that is why I'm here. Yeah, that's why I'm here. We've also been told a story. When President Uhuru was setting up the BBI thing, he was pursuing national unity. We've got the provision of Article 131, Clause 2C, where he has a duty, official duty to pursue national unity. Yes, I accept that. In fact, I encourage him to do that. In fact, I was very happy when he reached a deal with Appellant Raila to end electoral violence, because this process basically began from post-election violence that we're now basically playing out over here. That's where it actually started. And then the deal between the two of them, then comes the Gazette Notice, BBI Task Force, which doesn't have a constitutional change mandate. Again, he made a mistake there. He didn't consult the Public Service Commission. If I was Judge Mativo, I would have said it's unconstitutional because he didn't consult the Public Service Commission. He broke Article 132, 4A. But Mativo didn't talk about that, and therefore it passed through the court. And that is what is being used here as supposed to be the basis of res judicata. Yet it's a wrong decision. We cannot use a wrong decision. Fortunately, you're an appellate court. You're not bound by the findings of the High Court. You make your own independent decision. And I'm sure you will. And you'll be faithful to the law. But anyway, what we're being told is that we should allow Uhuru to set up, Appellant Uhuru, the BBI Steering Committee, because he's pursuing national unity. Where did we allow the president to break the law, to purportedly obey the law? I mean, in which country do you break the law to obey the law? Where? He should have been faithful to the law of setting up the BBI Steering Committee without a constitutional change mandate and seeking and respecting the authority of the Public Service Commission, getting the recommendation and doing things properly. If he did things properly, he'll be legally compliant and he'll be pursuing the national unity objective under Article 131, 2A. And that will be fine. I won't have any issue with him on such a scenario. But he went about it the wrong way. And so we say, don't break the law to purportedly obey the law. On res judicata, the other side has cited a lot of the case, the Third Way Alliance, and another versus Head of Public Service, Joseph Kinyo, and two others, as being the basis of res judicata. I won't spend too much time on it because Counsel Elias Mutuma yesterday dealt with it very ably. The parties are not the same. One is BBI Task Force, one is BBI Steering Committee. Task Force had no constitutional change mandate, Steering Committee had a constitutional change mandate. Therefore, res judicata doesn't apply. So those are just red herrings to waste our time here in court. But there's one good thing that came out from that case, not a ratio decision, but an obiter dicta comment by Judge Mativo, where basically he spoke to the basic structure doctrine, and I think you might want to have a look at it just to check his comments. He acknowledged we do have a basic structure in the Constitution, and he also highlighted what he called the great commandment of constitutional interpretation, Article 259. I thought those issues were good things from that judgment. So let nobody think that I'm against Justice Mativo. No, not really. It's just that he failed to consider Article 132 4A, the requirement to consult the Public Service Commission in setting up a body with respect to BBI Task Force. But otherwise, the obiter aspects of his judgment were pretty good, and I was very happy with them. Now, there's some other issues that are raised in my petition, which the court denied, which is basically Article 226, Clause 5. That imposes a personal financial liability on anybody who causes the loss of public funds on account of breaking the law or acting without authority. Now we had asked for a prayer that Appellant Uhuru be found personally liable for all of the expenses of the unconstitutional BBI Steering Committee and the entire process up to the point we've actually reached over here. Now the lower court actually used a technicality, not quite a technicality, but there is an opportunity to dodge issuing that very difficult and tough decision which would have set the standard for this country. They said because we had asked that the Auditor General compute the figures, they said correctly, Auditor General is an independent office, we can't order the Auditor General around and everything else, therefore we're not going to grant you your prayers. But we agree with you, Article 2265 is valid, etc., etc., etc. Now in our prayers, we'd also ask for any other just order. Surely it was in the power of the lower court to remove the Auditor General bit and issue an order affirming Article 226, Clause 5, so that this nation knows, all public servants who are looting this country dry know when they break the law, they are going to have to refund all this money. Morara Omoke has filed a cross appeal on this particular issue as concerns Appellant Uhuru. I am asking you to affirm that particular cross appeal, and you make the finding that Appellant Uhuru should reimburse the National Treasury for all of the illegally used funds in the unconstitutional and illegal, null, void, and invalid body called the BBI Steering Committee, and everything else that has proceeded subsequently. We'd also ask for another similar order that other public officers be found to be similarly liable, and that the AG over here should be the one to do that job and ensure that all those people who are also responsible do that. If you use your discretion under the Rule 31 of the Court of Appeal rules, you can apply that. I know Advocate Kanjama in his impugned appeal had also asked for that, but since you struck out the appeal, that one seems to have gone by the wayside. But you have your discretion, so you know what to bring in and what not to bring in. A lot has been said about the basic structure doctrine. I don't want to talk too much about it. I did submit on it in the Superior Court, and there are references in my submissions to that. You might want to have a look at it and everything else. I will very freely admit some of the deeper thought analysis from some of the parties over here are better than those particular submissions of mine. So you can rely on the others. I freely admit that. Now, coming up to wrapping up some of the issues over here, I see with the time left, some of the issues that I wanted to thrash out, I will thrash out. I mean, there are several questions that were raised. I mean, those will just disappear. We'll just now force you guys to use your intellect and judgment to wade through them. We can't help you on those ones. But it is my general observation that the Kenyatta appeal dealt largely with procedural technicalities and attempted to elevate these procedural technicalities above substantive justice, contrary to Article 159, Clause 2D of the Katiba. Its approach is also duplicitous, arguing the law not based on facts, as should be the case, but based on fiction. Matters are introduced and then they argue the law based on fiction. We are here in a court of law, not a court of fiction. We use facts to arrive at determinations, not fiction. I therefore urge you to disregard all their fictions. Let's use fact and come up to correct findings, both of fact and of law. I mean, I'll give myself an example. When I found out by checking the law that Junet and Waweru could actually qualify as promoters, I've readily admitted it. I've taken a position slightly different from some of my fellow respondents, because Clause 4 of Article 57 includes them under promoters, but they were not the only promoters. It was them, steering committee, and another one undefined BBI, according to the published bill. So same thing should apply to them. They should learn to use facts, not fiction. I therefore basically humbly pray that you dismiss all these appeals that are based on the issues that I've covered. There might be a few tweaks here and there. You might be amending some of the orders of the High Court here and there because you're an appellate court, you're reviewing everything. I understand that. But in essence, the Constitution of Kenya Amendment Bill 2020 is an invalid popular initiative. It's null and void, dead on arrival. That one is finished. The main reason why we're here is that particular bill. That one is completely finished. If they want to appeal and take us to the Supreme Court, tunawangoja huku, no problem. We'll meet up there, no problem. But in terms of proper jurisdiction, I mean, they shouldn't waste anybody else's time. This thing should end at this appellate level, and if they want to change the Constitution, let them follow the proper procedure. One amendment at a time. Don't bring us multiple amendments. One amendment, one bill containing one amendment. If it contains anything above the amendment to the Constitution, it should only be amendments, plural, on national legislation that are affected by the amendment to the Constitution, but not anything else. I have an apology to make to my fellow respondents. Time has cut me out. I can't address all the other issues that were left out that should have been addressed. I also haven't addressed 2/3 of my presentation because I was supposed to have 2 hours. I was only given 45 minutes. And therefore, that's just the way things are. But generally, I thank you for your time, and I pray that you do the job that Kenyans put in those offices to do. Uphold, respect, defend this Katiba of ours, and don't let anybody especially a mere employee of ours. Hata kama yeye ni employee number one, he's just an employee of ours. Don't let him ride roughshod over us. We are the sovereigns. We are the people. And therefore he must obey and follow our law. Thank you very much.
Thank you, Mr. Aluochier. We now move on to the appellants. You have 15 minutes each to make your response. Sorry. Yeah. Let's take a 10-minute break, and then when you come, the appellants be ready to make your quick responses.
This conference is now